Hi, I'm Steve Spencer with the Maine Department of Labor's Wage and Hour Division. One of 6 inspectors. We have 4 inspectors with large geographic areas, one that handles primarily prevailing wage and foreign logging statutes, and one inspector that primarily is assigned to child labor issues. Today I'll be talking about salary exempt criteria as they relate to wage and hour laws, and going through a presentation to walk you through that process. In most cases, one or more employees is going to lend itself to the state of Maine having jurisdiction over wage and hour issues. There are certain exemptions. Some of Maine's laws have their own number of employees that apply. Family medical leave requires a worksite to have more than 15 or more employees. Earned paid leave relates to more than 10 employees. Sexual harassment training has a cutoff that applies to 15 or more employees at workplaces as well. Work is defined in Maine's employment law. To employ is to suffer or permit to work, and an employee is defined as any individual employed or permitted to work by an employer. We're going to go over salary exempt and non-exempt criteria, starting with salary exempt criteria. In order to be considered salary exempt, an individual must be paid on a salary basis and must be paid a predetermined fixed amount regardless of the hours worked. There is a minimum salary amount in the state of Maine at $700.97 per week. There is also a federal minimum salary at $684 per week. Currently, the state's minimum is higher than the federal minimum, so the state's minimum is what would be followed in order for that individual to be salary exempt. There are also duties in addition to the minimum salary that have to be met. Those are outlined in USDOL Fact Sheet 17A, B, C, and D that apply to administrative, executive, professional, and highly skilled computer employees. We'll go over those in the following slides. In order to qualify for the administrative exemption, all of the following criteria must be met. The employee, as mentioned previously, must be compensated on a salary basis at not less than $700.97 per week. The employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers, and the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. The duties are important to keep in mind, and not just the fact that the nature of the work may be administrative. In order to qualify for the executive exemption, all of the following criteria must be met. Again, the employee must be compensated on a salary basis of not less than $797 per week. The employee's primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. The employee must customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent. As an example, that could mean directing the work of 2 40-hour per week employees or directing the work of 4 20-hour per week employees. The individual must have the authority to hire or fire employees, or the employee's suggestions and recommendations as to hiring, firing, advancement, promotion, or any other change of status of other employees must be given a particular weight. In order to qualify for the professional exemption, all the following criteria must be met. The employee must be compensated on a salary or fee basis at not less than $700.97 per week. The employee's primary duty must be the performance of work requiring advanced knowledge, defined as work which is predominantly intellectual in character, which includes work requiring the consistent exercise of discretion and judgment. The advanced knowledge must be in the field of science or learning, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. It's important, again, to remember that it's not so much the nature of the work being professional as it is these exact duties must be met by the individual working in that job category. In order to qualify for the creative professional exemption, again, must be paid the $700.97 per week amount, and their primary duty must be the performance of work requiring the invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. The United States Department of Labor fact sheets go into some detail. Fact sheet 17A as an alpha in particular goes into detail and indicates that these are generally met by some actors, musicians, composers, soloists, certain painters, writers, cartoonists, etc. And more detail, again, can be found in fact sheet 17A related to that. There's also a computer employee exemption. The same $700.97 criteria applies to this. As far as the duties, the primary duty must consist of the application of systems analysis techniques and procedures, including consulting with users to determine hardware, software, or system functional specifications. The design, development, documentation, analysis, creation, testing, or modification of computer systems or programs, including prototypes based on and related to user or system design specifications. Design, documentation, testing, creation, or modification of computer programs related to machine operating systems, or combination of the aforementioned duties, the performance of which requires the same level of skills. Again, these duties are important to keep in mind. Not every employee who interfaces with a computer will meet this. In fact, the vast majority of individuals who work in a field that use a computer will not meet this exemption. There's more information on this in USDOL Fact Sheet 17E as an echo. There are allowable deductions from salary. Full day absences for personal and sick reasons may be made. If an employer has paid sick policy and the employee has exhausted their accrued leave, then that time could be deducted from their pay accordingly. Likewise, there are allowable deductions for jury duty, certain penalties and suspensions. The first and last week of work can be prorated accordingly, and likewise, FMLA deductions may be made in certain circumstances. Non-exempt salary positions can also be paid. They're paid a predetermined fixed amount each week, but they are eligible for overtime if they work over 40 hours in a work week, and likewise, they would be entitled to minimum wage. These are individuals who would not meet the USDOL's FLSA salary exemption definitions. Under the FLSA, non-exempt employees can be paid hourly salary, piece rate, commission, etc., as long as their weekly compensation equals at least minimum wage for all hours worked, and overtime is paid for hours in excess of 40 in a work week. Going forward, things not related to salary exemption, but other laws that are relevant in the state of Maine. Employment records are required to be maintained by employers. They must be true and accurate records and include dates worked by employees. The amount paid must be a daily record for time records, and not required for exempt employees paid a fixed amount regardless of hours worked. So that would apply to salary exempt individuals that we talked about earlier. Hours worked must be on each pay statement for non-exempt employees, and they must be made accessible to the Department of Labor for inspection if requested. Maine's minimum wage is currently $12.15 an hour as we speak right now, with the minimum direct service wage being $6.08 as we speak right now. As of 1/1/21, minimum wage is tied to the Consumer Price Index. So while it did jump in dollar per hour, jumps up until the year 2021, from 2021 forward, it will continue to be tied to Consumer Price Index for increases. There are exemptions from minimum wage, which are outlined in section 663, subsection 3, A through L. We won't go into detail on all of those, but you can locate those there if you need to. Overtime is required to be paid at 1.5 times the employee's regular hourly rate. Weighted average calculation is used for overtime if an employee has multiple rates of pay. For example, if an employee works as a dishwasher in a kitchen and they also work as a prep cook in a kitchen, and each of those two have different hourly rates, the weighted average calculation is used to determine the regular hourly rate and thus the half-time amount that would apply. There are exceptions to overtime in 664 subsection 3 A through L. Likewise, there is a carve-out for comp time for public employees only. Private sector businesses are not permitted to use comp time by overtime laws. The United States Department of Labor does have an overtime calculator, and there's a link to that in PowerPoint. It would be important to remember there may be state laws that will differ slightly from the United States Department of Labor calculations. However, the calculations are very helpful. There are laws related to wages, which indicate there are all forms of compensation, and these would be legal tender in the United States, of course. There are laws related to automatic pay card requirements and fees. Essentially, an employee should be able to remove all funds from the card in a one-time transaction with no fees to them. there may be other allowable fees not related to that. There is a law regarding service employees that indicates those individuals are the ones that customarily and regularly receive more than $30 per month in tips. There's a law regarding timely and full payment of wages. There must be a regular payment made to employees on an established pay day at regular intervals made known to the employee, intervals such as weekly, biweekly, etc. Increasing the interval between pay dates requires 30 days written notice in advance to the employees. Lowering the rate of pay requires 1 day advance notice to the employee. It's always good to have a calendar available if you're curious about compliance with regard to these statutes. Regular intervals not to exceed 16 days. If you find a date on a calendar, point to that and then count back 16 days. It's very easy to determine compliance. Likewise, the law indicates that the payment must include all wages earned to within 8 days of the payment date. Using that same method is an easy way to determine compliance with regard to timely and full payment of wages. There are specific laws related to school personnel. If the employee works the school year, they may be paid over a 12-month period or shorter. They must have a written agreement, and this includes, but is not limited to, a collective bargaining agreement. Volunteer firefighters also have a series of laws that apply to them that indicate regular intervals are not to exceed 6 months in those cases. An employee leaving employment must receive pay for all hours worked, vacation pay if in accordance with an employer's policy, earned paid leave if in accordance with an employer's policy. They must be paid no later than the employee's next established payday. So essentially, that employee should be paid just as if they hadn't left employment when it comes to paydays. Pay should not be held for any additional time. At that time, overcompensation may be withheld if authorized under Section 635. If an employee voluntarily terminates employment, the employer may deduct the full amount of overcompensation as specified in that law. A loan or advance may be deducted, and likewise there are remedies for unpaid wages in certain instances. With regard to overcompensation mentioned previously, the overcompensation may be no more than 10% of the net pay, and there are certain exemptions related to coverage if the employee knowingly accepted overcompensation. There's a law related to unfair agreements that indicates employees should not be working without compensation, and it limits what deductions can be made for a debt. A debt is defined by that law as a benefit to the employee. It is not allowed for the cost of doing business. So say, for example, if a service employee drops a piece of glassware and it breaks, that may not be deducted from that service employee's pay. That is the cost of doing business in the service industry. Deductions are allowed for service fees for public employees related to collective bargaining agreements, and reimbursement of arrears cannot exceed in each payment 10% of the gross pay owed. Likewise, court-ordered wage garnishments may be deducted from employees, and the employer can deduct a $2 processing fee for those as well. Unfair contracts is a statute that essentially indicates an employer can't, by special contract with an employee, exempt themselves from any part of that particular subsection of laws. So an employer cannot have a valid contract with an employee that exempts itself from minimum wage, overtime, record keeping requirements, etc. There is a law in the state of Maine that provides rest breaks to employees, or that indicates employees should receive rest breaks. Employees, as defined in Section 663, must be offered a rest break after no later than after 6 consecutive hours worked. They must have at least 30 consecutive minutes of relief from duties, and it may be used as a meal time, and it may be paid or unpaid time. The law does not require that time to be paid, but an employer may choose to if they wish. There are exceptions. Does not apply to emergency situations in which there is danger to property, life, public safety, or public health, and likewise does not apply to small businesses when fewer than 3 employees are on duty at the same time, at the same location, and the nature of the work allows frequent paid breaks. The and is important there, that is not an or. There are situations where rest breaks do not apply. An individual employed in agriculture as defined by Maine's employment security law may not necessarily be offered a rest break in accordance with that statute because of an exemption. Likewise, employees who work in sales, work related to sales commission, whose hours and places of employment are not substantially controlled by the employer. This is an outside sales exemption. Likewise, taxi cab drivers, counselors, junior counselors, counselors in training at camps, individuals employed in the catching, taking, propagating, harvesting, cultivating, or farming of any kind of fish, shellfish, crustaceous, sponges, seaweed, etc. Your usual aquaculture positions are also exempt from Maine's rest break law. Likewise, certain home workers, members of the family of the employer who reside with and are dependent on that employer. The salaried executive employees that we mentioned earlier are exempt from Maine's rest break law, and likewise, certain sentenced prisoners, as indicated below. There have been a series of recently passed and amended laws that we'll go over now related to a number of different topics. Tip pooling indicated that this can only involve service employees. While tip pooling has been in flux at a federal level, in the state of Maine, tip pooling can only involve the service employees themselves. 625B severance pay, the notice requirements have changed on that. Important to recognize that not all individuals who separate from employment are entitled to severance pay in the state of Maine. There are very specific criteria related to large closures. 628A is a compensation history statute that indicates an employer may not use or inquire about the compensation history of a prospective employee from the prospective employee or a current and former employer of the prospective employee unless an offer of employment that includes all terms of compensation has been negotiated and made to the prospective employee, after which the employer may inquire about or confirm the prospective employee's compensation history. Earned paid leave was a new law that passed and went into effect in 2021. This includes most employers with more than 10 employees in Maine for more than 120 days in any calendar year. This includes all types of employees, full-time, part-time, temporary, per diem, etc. 1 hour of earned paid leave is accrued for every 40 hours worked up to 40 hours in a defined year for the minimum requirements to be met. Employees can use up to 40 hours in any defined year. Employers can apply a 120-day wait period before new employees can use their accrued earned paid leave. Earned paid leave can be used for any reason, such as emergency, illness, sudden necessity, planned vacation, etc. An employer can require the use of 1 hour increments for earned paid leave and may choose to allow the use of leave in smaller increments. There was a restriction on non-compete agreements made by 599A that indicates an employer may not require or permit an employee earning wages at or below 400% of the federal poverty level to enter into a non-compete agreement with the employer. 2021's federal poverty level is $12,880. 400% of that is $51,040. An employer shall disclose prior to an offer of employment that a non-compete agreement will be required. A similar statute passed related to restricted employment agreements. This is an agreement between 2 or more employers, including through a franchise agreement or contractor and subcontractor agreement, and prohibits or restricts one employer from soliciting or hiring another employer's employees or former employees. An employer may not enter into a restricted employment agreement or enforce or threaten to enforce a restricted employment agreement. And this carries a significant penalty of $5,000 minimum for violations of this new law. Section 809 provides leave for absences for emergency response. It prohibits an employer from taking disciplinary action against an employee for missing work because the employer is responding to an emergency in the capacity of firefighter or emergency medical services person, and the employee reported to work as soon as reasonably possible after being released from the emergency. Noteworthy is that this is not necessarily paid time off, but this is a job protected leave statute. 810 is very similar in that it allows an employee who is certified in search and rescue operations to report to work late or leave work early as a result of responding to a search and rescue operation as a volunteer. Section 639 put forth some wage theft remedies. These can include a violation of timely and full payment of wages, record-keeping requirements, cessation of employment, unfair agreements, fringe benefits, and minimum wage and overtime violations. It gives the Wage and Hour Division the ability to issue a cease operations order if the employer committed wage theft or the employer's practice or policy has resulted in wage theft on more than one occasion or within the last 12 months, and the wage theft affects 10 or more employees, or the wage theft is equal to or greater than twice the employee's average weekly wage. Section 638 provides leave for appointments for veterans. Employers must allow veterans to take time away from work to attend scheduled appointments at a VA hospital. The employer must allow the employee to use paid time if available. If paid leave time is not available, the employer must grant unpaid leave. Section 1304 for public works includes public schools and all buildings, roads, highways, bridges, streets, alleys, sewers, ditches, etc., and all other structures upon which construction may be let to contract by the state and which is funded in whole or in part by state funds, and for which the contract amounts to $50,000 or more. The large change here would be in the dollar value of that from prior times. Section 621A4 indicates that school administrative unit personnel who are paid on an hourly basis can be provided with the option of receiving pay over a period of 12 months or shorter. 598A, related to prospective employees' social security number, indicates that an employer may not request a social security number from a prospective employee on an employment application or during the application process for employment, except for the purposes of substance abuse testing under subchapter 3A or a pre-employment background check. This does not apply to an employer's request for a social security number after the employee has been hired. Section 3502 established a process for apprenticeships in energy facility construction. A construction employer shall, to the extent qualified apprentices are determined to be available in accordance with the rules adopted by the department, employ a number of apprentices that equals at least. And then there are a number of different criteria that are to be met based on the years as they go forward, established by that statute. There are a number of employment posters that are required to be accessible to all employees. The regulations of employment, minimum wage, employment of minors, Whistleblower Protection Act posters have been around for a number of years, and you may be familiar with those. A sexual harassment poster was made mandatory in more recent years. Human trafficking awareness posters were a relatively recent change as well. Human trafficking awareness posters are only required for certain types of employers. Not every employer must have that displayed. Those that are required to have it must make it actually visible to the public as well, not just the employees. And likewise, there's also a video display terminal safety posters. These can all be downloaded for free at our website, which is indicated on the slide. There are additional trainings available similar to the salary exempt presentation that you just watched today. These apply to hourly employees, tip service employees, child labor and work permits, and regulations of employment which are not related to pay. If you have any questions, the department contact information is found on this slide, including the website at the bottom, which has frequently asked questions.